Miranda rights and drunk driving in Indiana. You have the right to remain silent. Anything you say can and will be used against you. We all know a little bit something about Miranda rights. The general rule is that the police must read you Miranda rights if two conditions exist. Number one, you're in custody. A normal person would not feel free to leave. And number two, you are being interrogated. The police are questioning you. So let's apply this to traffic stops, which are usually the first steps in a DUI investigation. With a traffic stop, you are not free to ignore the officer's red and blue lights that are flashing behind you. And if you do ignore the red and blue lights, or you take too long to pull over, you will be charged with felony resisting law enforcement. That's a crime punishable like 2.5 years in jail. So a traffic stop is clearly not a polite invitation, and if you're pulled over, you're clearly not free to leave. And if the officer starts asking you where you're coming from, or if you've been drinking, clearly he's questioning you. So Miranda rights should apply, right? The basic elements are there. You're not free to leave, and you're being questioned by police. Clearly, Miranda applies. Guess what? Nope. The courts have consistently said Miranda doesn't apply to traffic stops, even when the traffic stop is clearly a DUI investigation. This all stems from a U.S. Supreme Court case that says traffic stops are non-coercive and not the same as being in custody, even though you can't leave. And since you're not in custody during a traffic stop, the questions an officer asks are not subject to Miranda warnings. The idea that traffic stops are non-coercive is ridiculous. You didn't ask to be stopped, you're not free to leave, and you're essentially forced to cooperate under the threat of jail. That is the definition of coercive. Calling traffic stops non-coercive is legal fiction. So in the overwhelming majority of the time, officers do not need to read Miranda for a DUI. But that does not mean I'm going to stop fighting that Miranda rights do in fact apply to my clients that are charged with DUI. I am constantly on the lookout for the type of DUI case that might qualify that Miranda rights need to be read. The ones that there's a solid argument Miranda needs to be read immediately are, number one, DUI cases involving an accident. Because in an accident case, it's even more clear a person is not free to leave. And number two, cases where the officer knows before they pull the person over, the person might be intoxicated. Basically, the officers have received an anonymous, or maybe not so anonymous, tip. I love to make Miranda an issue in DUI cases because so few attorneys give it any thought. And it's an avenue where you can truly catch the prosecutor off guard. The bottom line, unfortunately, Miranda does not apply in most DUI cases. That does not mean we're going to stop trying to find a way to make Miranda apply in each case that we represent somebody on. If a Miranda violation does occur, the only likely result is the statements are going to be kicked out, not the entire arrest is thrown out. If you've been pulled over by the police while driving a vehicle, the law requires you to give the officer your name, address, and date of birth. That's it. Or a copy of your driver's license. You literally cannot go wrong pleading the fifth to any question the officer asks you. Big exception is breathalyzer. You do want to agree to do a breathalyzer in Indiana, otherwise there will be catastrophic consequences for your driver's license. If you have any questions at all, give us a call, 317-632-3642. We will talk about Indiana criminal defense all day. Most importantly, remember, always plead the fifth.